Hello, everyone, and welcome back. Hard to believe it's been a year. It's time to talk estate planning once again. So often, a lot of questions we get around estate planning, a lot of concerns we get around estate planning. It's not easy to do, right? But it is, I would say, overly difficult other than, having some conversations. But noticing, still not enough people taking advantage of, what we have to offer as far as being able to help people, but also just not enough people, getting these estate documents in place. So we want to be here, be a resource for you, make sure we can answer the high level questions, and most importantly, make sure you can come to us for help in helping you or your loved ones or friends get this done for you. So with that, let's jump right into it. Let's get a refresh in on what is estate planning. What are we actually talking about? So really, it's about making sure things are handled the way you want, okay, both financially and personally. It covers a wide range of documents, a wide range of possibilities, but you have to have those documents in place first. But it's not just the physical documents. Estate planning is not just possessing those documents, right? Planning is planning. You have to think through what you want, your family, your friends, your loved ones, your charities, your churches. You have to think through what they all want, need, how they're going to play into this. But most importantly, it is all revolving around you. What do you want your post-death experience for the people you're going to leave money to, or the people you're going to put in charge to make tough decisions maybe when the time comes? You really need to think through all of those things. So with that, let's talk about what all does an estate plan include, Will?
Yeah. So an estate plan really encompasses four main documents, two documents that are utilized mainly while you're still alive and potentially incapacitated. Those are on the left there, the power of attorney and the advanced healthcare directive. So these are typically used in instances where you may get in an accident, you end up in the hospital, and you may not have the ability or the awareness to make decisions for yourself. You can appoint other people to make those decisions on your behalf, as well as the power of attorney lets your agent handle your finances and handle any medical bills or any other bills, anything related to your financial life, they will have access to if you become incapacitated. And then the two on the right are typically utilized after you pass. That is a last will and testament, which I'm sure we've all heard of, and then a trust, which is underutilized, but a very important piece of the estate plan. And again, these documents are very, very dependent on the situation, dependent on the actual person getting the estate plan done. Your situation may not require all four. Your situation may require a little bit more than these four core documents as well. But these are the four core things that are included in your estate plan that we'll be talking about.
Awesome. So the $1 million question is, who needs one of these things? Who needs an estate plan?
Yeah, that's a great question. I would say, everyone. Short answer. Most people think estate planning, right, is only if you're super wealthy or, you're super old, but that is just not the case. If you have any opinions about what happens to your family or your money or anything in the future, regarding your finances in your family, you definitely need an estate plan. Now, depending on how much control you want over your money after you pass, you may need more advanced estate documents. If you don't really care, you may need a little less, but it's important to be aware of the process that happens after you pass with your finances, and then determine whether you would like to create estate documents or not. We would recommend, always having estate documents in place, if not for the control aspect, if just for the simplicity that it provides your family once you do pass.
Yeah. So not just a thing for the ultra wealthy.
No, not at all. Not at all. Everyone needs to at least be aware of these documents, and most everyone, I believe, needs to have these documents in place.
Yeah, I agree. We often, do I really need a trust? I just have this little, yeah, if you care about the next steps, if you care about the people you've put in position to, help you facilitate the last beans of your finances, then yes, having this detail and organization, whether you're leaving 300,000 or 30 million, these people that you put in position to execute your estate post your death, they want your guidance, they want your opinion, they want you to have outlaid a plan for them. So yeah, definitely not just for the ultra high net worth. So here's a couple of additional reasons of why you would want to get some of these. Obviously, you own a home or property, right? Who's that going to go to? How are they going to sell it? Do you want to leave it to a person? These are very complicated pieces. They're often emotional pieces, right? Money is money. A dollar looks, the physical dollar is the same to everyone. It's easy to split that dollar up. But how are you going to split up, a piece of property or a vacation home or a lake house? Outlining these things are super important. You have kids, definitely want to make sure you've appointed who's going to be the guardian, who's going to handle them. Are they going to get money? When are they going to get that money? That's super important. You want to say in your healthcare or finances. So this is more on that power of attorney line item before you pass. Do you want to have a say in how your financial affairs are handled if you couldn't handle them for yourself? Or very importantly, how you want healthcare to be delivered to you should you not be able to make those decisions for yourself. You blended family, long-term relationship, that's very common. If you have a second marriage or even a first marriage, but there are kids that aren't involved in that marriage, then I think it's super important to have that designed out for both parties involved. Definitely. Own a business, right? So obviously I'm familiar with this one, like what would happen to my business if something happened to me? Who's going to take it over? What's going to happen to the money if I were to sell it? Who's going to get that? Super important there. But lastly, and most importantly, this is why it applies just darn near to everyone, is you want some peace of mind of making sure that, your hard work, your effort to accumulate, what you have, both the physical and the non-physical, the money is all going to go where you want it to go in the timely fashion you want it to go there. So what happens, if you were to pass without a will, you don't get to choose how your estate is divided, and that you kind of lose a lot of that control. So it's typically going to go to probate court. State laws are going to determine who inherits that money. They're distributed, as it says, to a formula, right? Not based on your personal wishes. What if there was a situation, we see this a lot, where, a parent gives some money to a child and they're just going to, settle that up upon the estate. Well, if you don't put that in writing and have that legally documented, then you go to probate and they just split it up evenly. And next thing you know, there could be, some animosity there. So that's super important. Guardians for your minor children, wouldn't you want to make darn sure who's going to be the person that's going to look after your kids should you not be able to? Obviously, we've heard horror stories of how long probate court takes and how costly it is. So that's a good reason to, try to avoid that best we can. And then lastly, and unfortunately, it's common, is just to try to avoid as much family conflict as possible, making sure everyone's on the same page. And the easiest way to do that is for you to just outline what those pages are ahead of time. So definitely important to get that will as a minimum put into place. So what happens, Will, if we have the will but maybe not the trust?
Yeah, in addition to, a will, we do encourage a trust, and a couple of reasons for that. One is to avoid probate. So if you do pass without a trust, what's going to happen is the will is submitted to the probate court, right? A lot of people think if you do have a will or a document that states your wishes, that it'll just bypass probate automatically, but that is not true. What happens if you just have a will is that will be submitted to the court. Then a judge, right, will appoint an executor or a personal representative to your estate, typically, a surviving spouse, or potentially an older child, or a child that's near, the previous home of the deceased. Then what will happen is they'll need to locate your assets, right? The executor or the personal representative has to spend hours, if not days, trying to find where all of your money is, especially if, typically people who do pass without estate plans probably aren't exactly the most organized, maybe sometimes with their finances, and they can have accounts spread all over the place and none of them are written down. And it's really, really hard to track down for your executor or your personal representative. After that, they'll need to identify who you had debts with, right? Another very, very difficult piece to determine if you're coming into a situation with no preparation and no, estate documents in place. Then they'll have to pay off debts and then prepare the taxes for the decedent. And then at that point in time, they will then distribute the remaining assets based on the decedent's wishes. If you have a will, if like Sean said, if you don't have a will, then the assets will be distributed based on a formula set by the courts in that case. So it's a very long process. Throughout this process as well, you have to keep the judge informed and the courts informed. And you can see it takes around 12 to 18 months. And all throughout that time, you have to continue to pay probate costs and court fees that could potentially cost 2 to 7% of the total estate, depending on your estate size. So that's very costly. I mean, that's 2 to 7% of your money, right? That is just getting taken by the state to facilitate something that can easily be facilitated beforehand and not even include the state in this process at all if you utilize a trust properly. So that is why the trust is so important. That is, why we take estate planning so seriously, just simply because it is very, very costly if you don't. And just a little bit of effort, right? Just a little bit of effort, a little bit of forethought up front can make this process so easy for your descendants and your beneficiaries and keep more money in their pocket as well.
We often get a little bit of pushback, and obviously we do estate plans here. We work with a third-party company, and it's very affordable, if not free, when you're a client of ours. But even if not, even if you're going to an estate planning attorney, sitting down, going through that whole process and paying, upwards to $5,000, if you have a super unique situation and lots of, nuance, maybe you do pay $10,000 or $15,000. That could absolutely be a nothing burger compared to what you might end up paying going through that probate cost, and obviously reduce a massive headache for those that you're leaving behind. So yeah, big deal there to make sure we can get at least one of these in place, if not both, the will and the trust. So most importantly, I think a lot of people wonder, how do I get going? How do I get started? Well, first and foremost, if you're a client of ours, just call us, just text us and say, hey, this is something I haven't done. I'd like to get started. We'll send you a little questionnaire to get that ball rolling. So first and foremost, if you're a client, call us, we can get that ball rolling. If you're not a client of ours and you happen to be watching this, call your advisor, call a friend. You'll find someone that you can call. Google search, have an introductory call. There's so many estate planning attorneys out there that will do a complimentary call with you and just kind of walk you through the situation, the process, the cost, what it's going to look like. It can't get started without you initiating that process. So definitely just reach out and get the ball rolling. Once you do have that ball rolling, here's kind of what you need to do. First, you have to clarify what you want. I joke, sit down with your spouse, so maybe over a tall glass of wine and figure this out. This isn't the easiest conversation to have, but what do you want? What does your spouse want? What do your kids want? Who's going to receive the assets? Who's going to take care of the children? These are tough conversations. You have to, essentially plan for your death, and that's not easy to do. But it is something that needs to be done to have a fully completed, comprehensive financial plan. It includes the estate plan. So once you know the who and the what and the how, then you got to move to the inventory stage, right? Figure out where all your money is, where all your assets are, collectibles, the lockbox, the safe, the Folgers can, the backyard, wherever all this stuff is, get it written down on a piece of paper, take full inventory of everything you have.
I think this is the most important piece that oftentimes gets overlooked. Is the estate plan is, yes, for the legal process of how it easily flows to your beneficiaries, but more often than not, it is just having one binder, one specific set of papers that tells the people that are still around after you're gone, this is what I have and here's how to find it. And that is just such a game changer when it comes to navigating life post death of a loved one, especially a very, very close loved one, making it easy as possible on the people you leave behind will really, really go far in just keeping their life as stress-free as possible, especially given the circumstances. A lot's going to be going on, but if you can make their life as stress-free as possible, I know they're really, really going to appreciate it.
Yeah, it's one of the reasons why, it's not necessarily a rule or a requirement, but a reason we stress that if you work with us, if you're a client of ours, that we manage all of the money that we can for you. If it can be here, we want it to be here. Not obviously for all of the synergies and, of the tax planning and investment management and all that, but for this reason right here, to not send your kids or your spouse or your loved one on a wild goose chase, tracking down everywhere you have a few $1,000s. Get that stuff all in one location. Make it as easy as possible on you pre-death and make it easy as possible on your loved ones post-death. Great point, Will. The next thing is to make sure you know who's going to do what, right? Those key roles. Who's going to be the executor of your will or your estate, your trustees, right? Who's going to make financial decisions for you? Who are going to make healthcare decisions for you? Who's going to, take care of your minor children? These are very, very important pieces to have ironed out. I just thought so. I'm like, well, aren't we probably should, reach out to those individuals and make sure they're comfortable and okay with being named in there. Last thing you want to do is name a guardian of one of your children and, something happens to you and that person doesn't want to do it. So, sit these people down and make sure they're okay being listed for these specific roles before these documents get created. Lastly, we got to build the estate plan, right? So it's taking all the inventory, taking the roles, putting that information on paper, getting all of these documents created, signed, witnessed, notarized, right? Getting that fully done. Something we do here, and I encourage everyone to do this, obviously you're going to have the physical documents in your possession. Make sure you have a digital copy of these documents. Make sure they are stored somewhere online where you can easily access them if you happen to be on vacation, right? And you need that power of attorney document. Make sure you can find them somewhere online as well. So once you have those documents physically built, then the reality is this is kind of where the nuanced legwork kind of starts, right? Like it doesn't really do any good. This is a misconception. I'll do my best to describe it. Will chime in if you can. So, building that trust, let's just use the trust, for example, really means nothing, right? Until you fund the trust, right? So having the trust established doesn't really mean anything unless you send assets, whether you either have to do two things. Put assets in the trust right away, right? Your home, any after-tax accounts you have. If you have a joint account, you can make that a trust account. Same with an individual account. But you also need to go do the transfer on deaths, the payable on deaths, the beneficiaries, right? Upon your death, assets need to be transferred from whatever account they're in into the trust in order for the trust to follow the rules. If you have Go ahead, Will.
I was just going to say that is definitely correct. A great point. Also, how we create these documents, we create what's known as a pour over will. So anything that doesn't, if you do forget something or don't title something correctly, the process will still go through probate to determine, if not everything is included or deeded to the trust, your will still go through probate for any assets that are not included in the trust, and they will then get distributed to the trust. So there is kind of a catch-all, right, for anything that you forget. But that is a great point, Sean. You do definitely want to make sure that you are funding this trust and, making sure that the beneficiary titles on a lot of your accounts, if it can't be put directly into the trust, do list the trust in some capacity so that everything can funnel into that trust and avoid probate as much as possible.
Yeah. And I think, for us and all the estate plan attorneys I've ever worked with, all of us, and I'm not a estate plan attorney, but all of them and us, we have a checklist, like we're not going to just leave you out to dry, anyone they're not just going to say, okay, now go do the next step. We've got a checklist. Any estate planning attorney is going to have a checklist for now that your trust is established. go do all of these things to make sure you get it fully funded. So once we have it built and funded and everything's ready to go, how often should we be revisiting this estate plan, right? This is not a one and done situation. Just like financial planning, right? ING, the act of continual financial planning, it's the same with estate planning, right? It's the act of continually to make sure these documents are updated. The rule of thumb is every 5 years. Internally here, we check in every 3 years. So for every 3 to 5 years, be looking through these documents, making sure the right people are still listed, the right kids, the right grandkids, the right beneficiaries, the right charities. Did your church change names, or did you start going to a different church? Were you leaving them money? Got to review all this stuff. In addition to just a time frame of every 3 years, you want to definitely revisit this estate plan should anything listed here happen to you, right? Death, birth, child turns 18, marriage or divorce, significant changes to wealth or health. That's a super important one. If something happened to your health where you are in a unique situation, maybe your original healthcare power of attorney is not in a position to handle maybe a tougher situation, right? You might need to change that person. Obviously, moving to a different state, any legal changes, legislation changes, or you change your mind about the people or the process in which that estate plan is going to be facilitated. So definitely review this estate plan as often as need be to keep it updated. And then lastly, Will, how do beneficiaries play into all of this?
Yeah. So like you said earlier, right? Just because we have the documents does not mean that everything is completed. So beneficiary designations on accounts, they really override anything that is, either state law or on your documents that haven't been properly funded yet. The beneficiary designations on your accounts are ultimately who those assets are going to go to. So definitely make sure that you're updating your beneficiaries as soon as you get your estate plan done to accurately reflect your wishes in your estate plan. What we like to do is on any retirement accounts, right? You list the spouse first, and then you list the trust as a contingent beneficiary. This is for some special tax rules, mainly as you see on the screen there, the spousal beneficiary rule in IRAs. They can roll that balance over to their own retirement account, deferring some income taxes and creating a little bit better of a tax situation, as opposed to making all of the assets be withdrawn in 10 years if you leave it directly to a trust. And as well as the trust tax laws are a little bit less favorable than the individual income tax laws there. So as you can see, definitely don't want to leave the beneficiary empty, as well as you'll see next to the no designated beneficiary. That must be paid out over 5 years, and just loses a lot of flexibility when it comes to tax planning. So make sure that the first beneficiary is your spouse. Contingent beneficiary then would be your trust.
Awesome. And then lastly, we can help you. So full disclosure, we are not estate planning attorneys. Nothing that we said today is supposed to be taken as, estate planning advice, right? It is education and, most importantly, encouragement. That is the role we're serving here. We do work with a third-party vendor called Trust and Will. So super well known. You've probably seen their commercials. We have an advisor portal with them. We pay an annual subscription fee to get about 100 plans a year is what we get on it. You can see the QR code here on the screen. You're welcome to scan that. That is our link. You can go online. You can get the process started. You can start punching in information, answering questions. You can always save and come back to it. You can always save and reach out to us if you have any questions. But definitely feel free to scan that QR code and get started if you haven't. You can also contact Leah with any questions. If you run into any errors or if it's asking you to pay, reach out to us. We can help you because there's a little glitch in the system, but we can help you do that. If it prompts you to pay, you do not need to do that. A nice feature about Trust and Will is if you do have, legal questions that we can't, from an education standpoint, help you answer, you can pay $2.99 to get a 1-hour consultation with a licensed estate planning attorney in your state. So it's a very nice feature working with Trust and Will as well. So anything else? Anything we missed?
I don't think so. Very, very important to get one of these done.
Absolutely. Appreciate your time, Will. Thank you all for joining. Thank you all for watching. Yeah, please reach out if you have any questions. We'd be happy to help in this area in any way that we can. So thank you for taking the time. We hope you have a great rest of your week.